Hello, welcome everyone to the IAPP web conference latest research findings on the state of CCPA and GDPR privacy rights compliance, sponsored today by CYTRIO. My name is Selena Lefebvre, a programming and speaker coordinator here at the IAPP. I'll be your host for today's program. We'll be getting started with the presentation in just a minute, but before we do, a few program details. Participating in today's web conference will automatically provide IAPP certified privacy professionals who are the named registrants with 1 CPE credit. Others who are listening in can apply for those credits through an easy-to-use online form on our website. I also want to let you know that a recording of this program will be available in your My IAPP, My Purchases, and My Recordings portal within 48 hours. Please feel free to post any questions you have for the panelists in the Q&A area at the bottom of the screen throughout the program for a designated Q&A portion for the last 10 to 15 minutes. And now on to our program, I'd like to introduce today's panelists. Firstly, I'd like to introduce Vijay Basani. Vijay is the founder and CEO of CYTRIO. As a serial entrepreneur, Vijay has a track record of building successful companies focused on solving critical business challenges in the data privacy and security industries. Thank you so much for joining us today, Vijay. I'd also like to introduce our next panelist, Anjay LaGoogle. Anjali brings over 20 years of security and data privacy experience to the panel. In her current role as the Product Security Officer and Data Privacy Governance Specialist for Cisco's Customer Experience Organization, Anjali specializes in data governance and cyber privacy issues. Next on the panel we have is Jim Rutt. Jim is the Chief Information and Chief Security Officer for the Dana Foundation. As an accomplished IT professional, Jim brings a lot of experience in leveraging technology to help reduce operational inefficiencies and improve business processes. And to round out on our panel today, we are joined by Cameron Huntley. Cameron is an attorney at VZN Law in Los Angeles, California, who works with his clients to better understand the necessary requirements for data privacy regulations. Thanks for joining us today, Cameron. And with that, I will now hand it over to our panelists.
Great. Thank you, Selena. So before we go to the panel, first 20 minutes we will take to review the research findings that CYTRIO has conducted over the last several months. To start off with, we'll start with how and what the state of CCPA was as of end of last year. Just to give you folks some insight into this, we basically researched about 5,200 companies end of last year, and we bucketized those companies into three buckets by reviewing their privacy policies and how these companies were responding to privacy requests. And the three buckets are companies that are using a commercial solution. We call them a compliant automation solution bucket. Second bucket is companies that clearly understand that they need to comply with CCPA, but they have chosen a manual processes such as email or 800 number to submit the privacy request. And the third bucket is non-compliant because these companies clearly state that they need to comply with CCPA, but they do not provide any mechanism for a consumer to submit the data requests. So we have primarily three buckets here. So as of end of last year, as you can see here, around 11% of the companies were implementing or have implemented an automation solution, a commercial solution out there. About 45% of them are using manual processes and 44% were non-compliant. And if you look at the data as of end of Q1 of this year, as of end of last week, basically, we have added another 1,570 companies to a total of 6,745. And the data points are pretty similar. Now, if you see similar little differences out there, I would probably put them under the margin of error. So we are seeing the consistent pattern here of about 11% of the companies or 10% of the companies using automation solutions, and about 80% or 89% or 90% of the companies using either manual or doing nothing out there, right? So if I go into the next slide, it basically gives you a side-by-side comparison of Q1 versus end of last year. Again, don't put too much emphasis on the bottom chart out here, but the takeaway from this data is that companies continue to implement commercial solutions, even though the percentage is around 10% out there. Increasing number of companies are deploying commercial solutions. as well as we also see a little uptick in the non-compliant bucket. We'll probably seek the panelists' help here when we go to the panel discussion to help us understand that our assumption at CYTRIO is that due to some delays in CCPA final regulatory text, we are probably seeing some hesitancy or some delay in some companies adopting CCPA compliant solutions. So the next chart, what we'll do is we'll now dive into the statewide compliance. And if you look at that, top 3 states under CCPA, companies that are in these states, top 3 states are California, New York, and Texas. And they comprise about 31% of the total companies that were in that pool of 50 to 100 companies that we looked at end of last year, right? And compared to that, you will see that there is an interesting trend here. As of end of Q1, the total of 6745 companies, about 24% of the companies were in that from the top 3 states. What it tells us is that more and more companies from other states are catching up with CCPA, which is a good trend, which is what we want to see as privacy practitioners. The next slide, we basically dove into state by state analysis of the top 3 states. So California, right now, as of end of last quarter, we are almost up to 1,100 companies that we reviewed and researched. And the percentage is consistent with what we have seen as of end of last year. You'll see the similar pattern in New York as well as in Texas. Interestingly, Texas companies, one takeaway from this chart is Texas companies tend to be laggards in terms of implementing commercial solutions, even though they understand clearly that they need to comply with CCPA. Okay. Next, we dove into vertical slicing of this information. And the top 3 verticals, which are business services, retail, and finance, constituted about 54% of the companies that we researched in 2021. Compared to that, the similar percentage held true even in Q1, as of end of Q1 of this year. As of end of March, the top 3 verticals remain the same. And the percentage that these 3 verticals constituted out of the total pool of 6745 remain the same at 54%. Next, we dove into the business specific, the top 3 vertical specific analysis. You will see again, the overall compliance automation within business services is staying consistent at around 7%, which is still again within the margin of error. And the non-compliant bucket has gone up a little bit. And again, as I said earlier, it probably might be due to the delays in the final text publication of CPRA. Okay. Similarly, under retail bucket, the compliance automation percentage is remaining consistent out there. And interestingly, you see a much lower percentage compared to other verticals with regard to non-compliant bucket. And the next slide is about finance industry. We were kind of surprised, but it can also be explained by the fact that finance industry comes under GLBA and FFIEC and other finance-related regulations. So you probably would see a little bit lower automation and compliance in this sector, but it is still consistent with what we have seen as of end of last year. Next, we dove into breaking it down by B2C versus B2B. Overall, you'll see there is almost a 50-50 division between B2B and B2C. And consistently, we have seen the percentage automation and compliance also staying consistent, whether it be B2B or B2C. So in B2B, we were at about 11% end of last year. And end of Q1 this year, we are still about 10.5%, which is again still within the margin of error. And when you come to the B2B, end of last year, compliance automation solution adoption was about 10%. And end of Q1, that's about 9%. The overall number of companies in the research pool is now up to 3,000 odd in the B2B bucket. Okay. Then we slice the data by the number of employees in the company. The first bucket was 100 to 1,000 employee companies. And there you'll see, again, about 10% adoption of automation solutions and about 42-43% in the what we call manual bucket, as non-compliant is about 47% here. Similarly, under the 1,000+ employee bucket, we see again a consistent pattern here, about 10% for automation solutions, manual processes about 42%, and 47% of the companies are non-compliant in this bucket. Okay. With that, I think it's time for us to do the first poll question. Selena. The question is, how do you rate your DSAR response preparedness? Please select one of the 4 options. You see a significant number of companies using manual processes. Interesting to see that we see a significantly higher percentage of companies using commercial solutions than what we have seen in our research, which is very heartening to see. Okay, so we have a pretty good amount of responses. I believe some more are coming in. We are at about 22% for commercial solutions, 63% for manual processes, and don't have anything is 9%. Do not need to comply is about 6%. Okay, thank you all. Share the results with everyone. Let's give another 2 seconds before we close the. Okay, great. Thank you. Okay, now let's dive into the second part of our research. In Q1, what we started is we also started looking at US companies that not only need to comply with CCPA, but also need to comply with GDPR. And so in the research of 1,570 companies that we researched for CCPA compliance, we were also looking to see if these companies recognize that they need to comply with GDPR, and they stated that they need to comply with GDPR. So there were 257 companies out of 1,570 companies that said they need to comply with GDPR. And then we, as earlier, we bucketized them into 3 buckets. And for the 100 companies that were using automation solution under CCP of this cohort of 1,570 companies, 12 of them have adopted an automation solution, and 9 of them are doing manual processes, and the rest are not doing anything, right? The second bucket was manual processes. We found 533 companies were using manual processes. Of those 533 companies, 134 companies said they need to comply with GDPR. And the third bucket was 102 companies, which are predominantly using manual processes, that are also the companies that are non-compliant under CCPA. Overall, 16% of the companies that said they need to comply with CCPA were also required to comply with GDPR as per their privacy policy statements. Of that, less than 5% are using automation solution, 95% are using manual processes. Then we broke this data into top states. And if you look at the top 5 states, you would see that 46% of the companies of whom they say they need to comply with GDPR come from these 5 states. Interestingly, 4 out of the 5 states are from East Coast. So I don't know if it is an anomaly or an interesting finding, but you'll see that 4 out of the 5 states are from East Coast. Then we looked into vertical-based data, and 77% of the companies that needed to comply with GDPR come from these 5 verticals. And you would see that pretty much all these verticals are B2C companies predominantly, and finance is missing. If you remember, under CCPA, finance was the 3rd top vertical. Here, finance is not even in the first 5. Next, we broke this data into based on the company size, employee size, as well as B2B versus B2C. There was not a market difference between B2B versus B2C in terms of automation versus manual processes. Similarly, if you go to B2C companies, as we said earlier, B2C companies were a lot more eager to implement an automation solution versus using manual processes versus B2B. So that ends our research findings. Would encourage you folks to ask any questions you might have about the research that we did and how we concluded with the data. Other observations that we saw and we found during Q1 were increasingly we have seen and we have heard customers saying that large percentage of the requests they're receiving are delete requests. And also they are telling us that increasingly more and more requests are coming from these aggregators. So those are the two common things that we have heard in the market that we thought we'd share. So at this time, we would like to go to the second poll question. Selena. So the second question is, what is holding you back from deploying a DSR automation solution? So we see not a priority, leading cost as a second, and deployment complexity as the third. So I'd love to see folks who are saying not a priority. Any comment you can make during the Q&A session, why it's not a priority. As a vendor, I'm very eager to learn about that. So cost and deployment complexity are tied as the second main reason. We'll leave the poll open for the next 10 seconds. Don't be shy. Love to hear your voice. If you haven't responded, please respond. Okay, looks like we are redoing this cost. Appreciate you guys responding to the poll question. Okay, we are receiving a very different set of responses. Cost is the leading reason at 63%. Five more seconds. Okay, we have 63% saying cost is the primary reason why they have not deployed an automation solution. Deployment complexity is at 19% and not a priority is at 19%. So for folks who have said cost and complexity is the primary reason, we have good news. We'll give you a reason why you should think about deploying a solution to automate your DSR and privacy response process. So with that, I would like to take next couple of minutes to introduce you folks to CYTRIO, what we do, and how we can help you folks. Okay. So at CCPA, we are a vendor that is delivering data privacy rights management, and our business value for folks is to help them fully automate GDPR and CCPA data privacy compliance. And we do this through an all-in-one data privacy rights management solution that delivers both data discovery as well as automated workflows. Quickly, overview of why there is a need for this thing. As we all know, data privacy regulations like CCPA and GDPR give consumers specific rights, such as right to access and right to delete and other privacy rights. And when a consumer makes a request, it is challenging for companies to respond to these data requests because all of us in today's digitized world deal with data sprawl across hundreds of data stores. And these regulations also come with strict SLA response times, depending on the type of regulation you're dealing with. Industry research says that on average, it takes about 8 to 10 hours at the minimum to respond to incoming data requests. And if you are a company that is receiving just 10 requests a month, you're going to be spending almost $170,000 a year, right? And most importantly, for folks who are deciding whether they need to comply with these regulations or not, just remember these regulations are very actively enforced. Last year under GDPR, over $1.2 billion of fines were levied. As of today, under GDPR, over 1,000 companies have been fined to the tune of almost $2 billion. So these are being actively enforced. We expect CCPA also to be following the similar trend out there. right? So any company that is looking to comply with GDPR and CCPA privacy rights management has to think about it following these 7 steps, right? First is, how do you provide a mechanism for a consumer to easily submit the data requests? Second one is, how do you validate the identity? Third one is, how do you triage and orchestrate the response process? Next, you need to have a mechanism to identify and correlate all the information that belongs to a particular requester. When we say all information, we're specifically talking about PI information. You need to have a mechanism to review and approve so that you don't accidentally share wrong information and thus creating a potential data breach claim out there. Then you need to finally securely respond to these requests and share PI information with the consumer securely. And then while doing all of these things, you need to make sure that you maintain a detailed audit record. And this is the reason why research analysts like Gartner are saying it's costing about, on average, if you calculate all the time and cost involved in responding to a request, it's almost $1,500 per request companies are spending. And this is where, based on our research and effort, we have figured out a way to build a cloud native SaaS platform. At the core of our platform is data discovery and the correlation of the PI data with the data subject identity. Built on top of this platform is 2 modules. One is a consumer facing portal that you as a customer of ours can easily customize this portal to meet your branding requirements. Literally takes 30 seconds to add your logo and change colors. As a consumer, when you log in, all it takes is 2 clicks to submit a data request. We intentionally chose to make it very easy for consumers to submit the request so that they can create and build the trust and transparency with the companies. On the other side, we also have this administrative console. So security and privacy professionals can collaborate using built-in workflows to respond to incoming data requests. We provide this built-in dashboard that gives you a high-level overview of how well you as a company are doing in terms of incoming data requests, along with SLAs in terms of response SLAs. And then it has built-in workflows that allows you to follow those 7 steps that we discussed earlier and capture all those details in a detailed audit log so that you can clearly demonstrate to the auditor that you're following a very well-defined process out here. And then more importantly, reduce the time to respond to those incoming data requests from weeks or hours down to minutes, and automate almost 80+% of the manual tasks that are involved in the process. So for folks who are attending today's session, we have a special offer for you folks. If you're interested in reducing your costs and deploying your solutions quickly, our experience has been that to date, on average, we have been able to get our customers up and running in less than an hour. So it's a very easy, simple solution that you're going to be deploying with CYTRIO. And from a cost perspective, it costs you nothing to get on our platform. We are giving an offer here for all of the attendees. It's going to be free until the latter of July 31st, 2022, or the first 6 DSARs, whichever comes later. So if you only receive 3 DSARs until July 31st, you continue to use the platform for free. Or if you just get, if you're getting 20 requests a month, you can use up all those 6 DSARs in the first month, but you'll still continue to use the platform for free until July 31st. So we welcome you to get in touch with us, come on the platform, and we'll promise you one thing, that is, we will reduce your cost of privacy rights compliance, and we'll reduce the complexity of privacy rights compliance. So we'll make it easy for you folks. So with that said, I would like to get to the 3rd poll question before we dive into our panel discussion. So 3rd question is, which group is responsible for privacy compliance in your company? IT security, compliance, legal, HR, finance, other. The initial response is the leading candidate group is compliance teams, followed by legal and other. IT security is beginning to come in at 13%. I think we have sufficient numbers to close the poll. So the final results are compliance leading as the compliance group leading at 41%, and followed by other, followed by legal at 26%, other at 18%, and IT security at 12%. Thank you. So with that said, I would like to welcome our awesome panel members, Jim, Anjali, and Cameron. So what we'll do is for the next 20 minutes or so, we have a bunch of questions that we have prepared for the panel members, and we'll go one by one. And at the end of the panel discussion, we'll open the session for Q&A. First question is to Jim, and please, other panel members, please welcome to comment also. Jim, reviewing the research data and the results that we have reviewed just now, do these results align with what you're seeing in the market?
Absolutely. I mean, it's interesting. You're talking about in terms of adoption rates, Vijay?
Yes.
Yeah.
Adoption rate, as well as the percentage of companies that say they need to comply with CCPA, but they have not done anything.
Yeah, so there's a bunch of different factors why, right? So when I think about, the progression as represented by the statistics that you put up in the presentation, as well as the responses from the poll, it mirrors very much the early days of our old efforts in compliance. Now, I'm a technical practitioner. I'm not a legal or compliance specific department head, but it reminds me a lot of the efforts around HIPAA, SOX, those types of things. Now, the biggest difference here when we're talking about data privacy is that they are non-sector specific, unlike, finance has GLP and healthcare has HIPAA, et cetera. So this is a wide-ranging, like almost all-encompassing form of compliance. And it's very interesting to see that there hasn't been a lot more focus on looking at ways to automate this, seeing as we've already gone over the hump in automating some of these things as I previously discussed. Now, if you talk about factors why this is true, I think you mentioned one. I think some folks are taking a wait and see approach in terms of the regulations themselves. I would argue that we have probably close to what we need to figure out what our roadmap will need to be to run a compliant privacy program for GDPR and the state-specific regulations. And by the way, I mean, seeing the progress of these state acts that as they're coming into play, I could foresee that happening pretty much across the state, the whole union. So I have to think about how I'm going to develop a program that is going to be cover all the areas of all these things at the most restrictive points, so I don't play leapfrog with these as we move along. So some of the other things that I think are interesting also as well is in terms of getting stakeholder consensus to bring some of these solutions on board. Be very difficult because you've got legal and compliance, which may not be as technically day-to-day involved with data management as someone like myself, and vice versa. I may not be up to date as to the absolute legal ramifications of every change with every one of these regulations. But all I know is, as a practitioner, I want to do the job one time, and I want to do it with the least amount of human intervention, because every hour that I have to spend complying with something like privacy takes me away from all of the other things that I'm charged with doing as the head of technology here at Dana. So it's I've got a bunch of other things that that come to mind that are probably very germane to most program implementations, but I'd love to hear from everybody else if I'm on the right track.
Anjali, would you like to comment? You have been involved in pretty extensive research at Cisco. You folks have been conducting and publishing research reports for the last several years, especially in the privacy area. Would you like to comment on?
Yeah, sure. So based on the research findings you presented, they definitely align with the current landscape we have in the privacy response ecosystem. And I would like to bucket these findings into 4 buckets mainly is the preparedness of these laws like CCPA, GDPR, and then the upcoming CPRA, and then the other ones from Virginia and Colorado. So the common theme is some are unprepared, some are kind of compliant. And this is going to be more pronounced when the CPRA will be rolled out by CPPA, right? And employees start exercising their rights. So that preparedness is number one factor which we need to address. Second one is there is significant variation if you see in the different verticals, the preparedness, different verticals. Some are leading the pack, some are trailing the pack, like media, healthcare, retail. So that is point number 2. Third one is the low adoption. As we saw, 11% of companies which you research have low adoption. And that indicates that maybe these DPRM, that is a data privacy management solutions, are not have gained wide adoption yet. I need to find the reasons for that. Though companies are taking longer to respond, why aren't they not really adopting a solution? So that's point number 4. And the fourth one is the DSR characteristics, right? If you see the volume, the frequency, which because of the influx of the data aggregators and the automated agents, then the source of DSRs, some have a simple form, some have a trust portal, some have the DSRs are coming in through email. So the source which they're coming through. So I think looking at the current landscape, the research, it calls for a need of transformation. The mantra which we all follow in our organizations, like people, process, and technology. So you're handling people's data, make sure that you automate this overarching process and put technology into operation. So that's my summarization.
Right. Cameron, do you have any comments on your end?
Sure. I mean, those were both very thorough answers, but I also agree. I mean, this aligns with what we're seeing too. I thought the CCPA versus GDPR comparison was particularly interesting, the data there, because they deal with different geographies. So I think it makes sense that larger companies, probably with broader customer outreach, obviously have more international presence and have to worry more about those kind of DSARs versus just, California or state specific. And I think one of the slides talked about B2C being kind of a higher level of requests. And I think that makes perfect sense too, because, I think it's individuals who are, who are customers, they're going to be the ones that are more likely to be concerned with data breaches or things like that, rather than someone who's an employee of a company that's, requesting their employer to get rid of that employer's vendor's data. So I think that all makes sense and it aligns with what we're seeing.
Right. So I would like to just add one comment to the panelists' responses there. And it kind of was confirmed through the second poll question, that is complexity and cost of these solutions also, especially first generation data privacy rights management or automation solutions also contributed to this low adoption rate. The second reason I think is that if we look at GDPR, it took them almost 2 years before they started picking up in the frequency and the volume of fines levied under GDPR. And for the last 18 months or so, we have seen increasing number of fines being levied under GDPR. I think you'll also see more companies that are on the fence, being motivated to do something with it as the fines under the CCPA start rolling out. So, okay. So the next question I have for you folks is, again, one of you please take the lead, and rest of you folks please comment on this thing. What are the top 2 or 3 capabilities that one should be looking at when selecting and deploying a solution to operationalize this privacy rights management? Jim, Anjali?
Yeah, sure. I'll start off. And so again, this is only through my particular lens, but I'm sure there'll be other angles that my fellow panelists will cover as well. But for myself, I want to make sure I'm selecting something that integrates with the maximum amount of regulatorily affected data stores. So I get the most complete solution and most coverage in terms of relating data between different silos, because one of the major problems, I didn't cover this before, is you've got regulated data in a bunch of different silos, how do you normalize it properly? That's an effort that you don't really want to do manually. And you want to make sure that you have some way of automating that, at a minimum visually, so that you get the most up to date and the most comprehensive picture of that. That would be my primary critical success factor, I believe, in selecting one, as well as the auditability or the ability to provide proof on demand in case I would say there will be, as these state-by-state regulations keep rolling out, and they will continue to roll out. I want to be ready to be able to respond in the quickest way with the least amount of overhead on my part to ensure compliance at the point of regulatory request. So those would be two.
I can go next. So there is a quote from one of the IIPP experts, Lee Matheson, and the quote says that without a good data inventory and mapping, no business can really accurately make a category-centric disclosure emphasized by the statute, let alone comply with the different verified requests coming from the consumers, right? So definitely the key capabilities, as it summarizes, is companies want to achieve, stay at the right side of the compliance. They want to achieve scalability, accuracy, timely response, and in cost-effective manner. So the first three key capabilities which come to my mind is it should offer intelligent data discovery powered by a smart search. It should offer intelligent data deletion mechanism that can also take into consideration the alignment of the PII elements, the PII retention requirements, the legal holds, and then execute the PII while making sure that you don't inadvertently delete the information, or you don't even retain the information, so verification. So, and the third one is automated verification of the requesters, because as we see influx of DSRs from agents and aggregators, the verification of the requester takes time. So automated verification tied to the PII within the system, because that is a cumbersome process. Equally important are data redaction and also documentation, because you really need to track the chain of custody to verify compliance. So to summarize, I think an intelligent solution with these capabilities, which can really balance the execution decision of individual DSRs alongside business needs, demands, and laws, which the companies need to abide by globally. That would really help.
Great. I think very well covered between Jim and your answer, Anjali. I think you basically are saying that we need a solution, make sure that it's a comprehensive solution that can identify and search and collate the data that belongs to the particular requester in an intelligent manner, and in a very efficient manner. And then make sure that you are able to maintain a clear audit log of everything, and that you're following the 7 steps that we covered out there. So it covers as many of those steps as possible. And one other comment I would like to make is that there are solutions in the market right now who can help you get these solutions deployed quickly without spending a lot of your time. And one of the things that we have learned and we continue to learn in the market is that, especially in the mid-enterprise market, if you go beyond that Fortune 500, increasing number of companies, the security team who are being tasked with taking care of privacy also. And in today's world, and for the last several years, having spent 15 plus years in cybersecurity market, I can clearly state that cybersecurity teams are still very much burdened with security challenges, and they don't have time to deal with privacy. And the more we can help them with automation and efficiency, the better it's going to be for the companies at the end of the day. So the next question I have for you, for the panel, is we are hearing that some companies are saying that they have not yet seen significant number of requests coming in. They're seeing only a few requests a month coming in. Should these companies be thinking about implementing a commercial privacy rights management automation solution, or should they be waiting? What would you recommend, Cameron?
I think it kind of depends on the company and who their base is. Some of my clients are very B2C, whether it's like e-commerce or retail or something like that. And they care not only about being compliant if they technically need to be, even if they're not getting a lot of requests, but they also want to have good customer relationships. And one way to do it is to be very privacy forward and privacy friendly, which is a really popular thing for consumers, especially in the retail market with big ticket data breaches years ago that made the news and the headlines, like Target. So I mean, there's a lot of factors to it other than just actually getting the requests or not. One is saying, this is what we believe in and we want to support our customers if they decide to remove data. Plus, if there's a spike, if there is some kind of big data breach that triggers a lot of people suddenly be concerned with their personal data more than they already were, then they should be ready, I'd say, for an influx.
Anjali and Jim, any comments you would like to add?
Sure. So, go ahead, Angela.
Yeah. So what I would like to say is, I think waiting for an incident to happen and then start automating your processes, like putting your seatbelt after you've met with an accident, right? So I think this is the time to really elevate your privacy operations. And the reason I say this because based on the key findings from the Gartner research, right, by 2023, I think 65% of world's population's personal data will be covered by modern privacy regulations. So that is up from 10% in 2020. And that says that consumers are going to become more aware of their privacy rights, worried about their privacy. There are so many self-service portals which are really becoming more prevalent than that they were before. And that will definitely increase the volume of DSRs, future events, even though the organizations are not getting substantial DSR requests right now. The future events like the breaches or public privacy incidents can result in more wave of these DSR requests. So knowing that to basically support this process, it's a very onerous process, it's cumbersome, it takes time to really understand your data treasure troves, build the data relationships, organize it, align with the product priorities. Knowing that it's a time consuming process, it's good to start preparing, and also good to start aligning your data governance objectives with the advanced data privacy rights management. So it's time to prepare proactively and be prepared. Yep.
Yeah, so I'll feed off of what Chairman and Angela said. They said it very well. I think also a couple other factors to consider is obviously your level of acceptable risk as an organization. It's also the perception of enforcement is definitely key. I think that's going to increase as you move from a more GDPR centric reported form of enforcement, which has the perception of being kind of overseas and not really in proximity to where a lot of US-based companies are, to now you've got state level enforcement of these regs, and you've got states that have certain fiscal needs and shortfalls in your budgets, and they can certainly use an influx of revenue for non-compliance. So that's certainly a big motivator, as well as I'd say not even just privacy specific breaches that are reported in the news. Any kind of breach is going to bring better awareness, especially in companies that may not be B2C, that, hey, listen, we need to circle the wagon, so to speak, and make sure that our privacy program, in concert with all of our other peripheral programs like data protection, are all up to speed and they've got the proper level of auditability, automation, et cetera, to make sure that they're all effective in whatever responses they need to get.
Great. We'll cut over to Q&A in a couple of seconds. A couple of final questions before we cut over to Q&A. So Anjali, now we are seeing these DSR aggregators pop up all across the industry. Do you see the trend continuing, especially with CPRA giving them almost legitimizing the aggregator business?
Yes. Definitely. I think the short answer is yes. We are seeing a lot of it, not we as Cisco, but in general, the research, the findings shows that indicates that there are a number of DSRs coming from as a result of the aggregators or authorized agencies increasing, because they really allow the consumers the ability to submit DSRs to multiple companies, right? So it's easy, just with a single click of mouse, you can submit DSRs, you can, you know your rights, so why not demand your rights, right? And the research from Automated Intelligence, which is a body which represents the UK DPOs, that has reported that there is around 66% increase in average number of DSRs received. So if you really think what brought this large jump in the DSRs, it's an amalgamation of multiple factors. One is increased consumer awareness. Then there is a turbulence in the employment dynamics. So you expect DSRs coming from employees as well. Number of breaches reported, which scares people, and then it's a herd mentality. They go and okay, maybe submit a request, right? So another factor is given the lack of procedures for generating and processing requests, these agents are helping consumers, right? The agents are authorized, they're strengthening consumers' power, they're authorized, but that also causes for security risk, because you are giving more power into the hands of these agents or DSR aggregators. So it's a combination. It needs to strike a right balance right now, but definitely we are seeing an increase in DSRs coming from aggregators.
And as a follow-up question, Jim, what are the challenges that you see when a request comes from a DSR aggregator? It's not the same as somebody sending an email to your privacy at CYTRIO.com or submitting a request on a portal. What is it different from a request coming from these aggregators, and what is the challenge that you see out there?
I consider, I really don't have anything that unique to say. We would consider any kind of right to delete, the right to access request from an aggregator with the same importance as an individual requester. I kind of would like to add, as well as I'd like to see a lot more transparency around these DSR aggregators, because of the methods that they use to collect information from these consumers that are leveraging them essentially as a proxy for submitting to multiple data holders, for lack of a better term. I think there's going to be some unintended consequences as a result of some. We don't really know what the ulterior motive of a lot of these aggregators are, besides a subscription-based revenue stream, what they could be doing with the data in total that they're collecting from these consumers as a result of having to determine where to send these requests. There could definitely be some monetization schemes that they might have that may either cancel out the whole idea of a consumer looking to protect his or her privacy, as well as run afoul of some other regulatory things. So I think it's an interesting concept from both sides, both from data owner and data requester. But there needs to be a lot more transparency as to the business model and understanding what goes on behind the veil.
So I'd like to add to that, some of the conversations that we had with actual customers who are dealing with these requests from DSR aggregators is that it is challenging, because these aggregators just forward an email. They have these automated systems that spit out email to companies. And they basically say, we have a request from this customer, coming to our portal to find more details. And it becomes, even if you had implemented a solution, it becomes a manual process. And one of the things that we tell our customers is, these are aggregators here. They're here to stay. They're going to increase in volume. They're going to become a bigger nuisance for you. So make sure the solution that you're selecting also has a mechanism to help you automate the process. Now, how do you take in the requests? How do you bulk upload those requests? Or, if there is an API, how to connect to an API through the system, pull in those requests and automate the whole process. As Anjali said earlier, starting with validating the identity of the requester all the way down to responding to the request in a timely manner and efficient manner. So one of the things I would want to share with all of you is make sure that's also one of the requirements you are putting as a condition in selecting the right solution for your data privacy rights management. So with that, I want to thank the panel's members for answering the questions. Now we would like to cut over to Q&A session. So I would encourage all of you to submit your questions and we will respond and we'll answer as many as possible. The first question for the panel is, what type of reporting metrics would you recommend tracking? Anjali?
Metrics in the sense related to DSRs, or in general for at the global privacy laws and regulations level?
DSRs.
DSRs, okay. So definitely, I think the metrics, if you look from the assessor or the auditor's perspective, you have three types of audience, right, to the metrics. One is the businesses. Your CEOs or the leadership can see, okay, how is the company performing? How is the company compliant to privacy regulations? So metrics for them, metrics for the technical team, so that they can really go back and maybe if they're not automating, then go back and ask the different stakeholders who are responsible for the binds, and then the auditors, assessors, compliance committee, right? So the metrics could be that, okay, the status of how are we performing, basically the delayed response, right? Because that's one of the biggest one. Are we responding in time? Are we being compliant? So if there are delays in responding, why are we delays? Any false responses, for example, that, okay, you responded, but you responded in a fraud way. So that really identifies a gap in the process you have. And then from the leadership perspective is, are we really getting out the competitive benefit from this? Are we making sure that the customers will be satisfied or the trust will retain? So different kind of metrics for different kind of audience.
Yeah. So I would add to that, Anjali, all very good points. On the audit side, make sure that you are able to not only your system, the you select has the ability, gives you the ability for you to go and look back if there is an audit, because auditors always want to look back and see that you're compliant at a certain point in time or continuously. So your system should maintain all the record of all the actions and activities you have taken. Second one is also make sure that the system is select allows you to generate periodic reports that you can archive and you can share with the different constituencies within your company, using your executives as well as technical people and privacy team members, right? So make sure that the reporting is clear and succinct and it can be automated. So the next question, Jim or Cameron, would you like to add anything to that?
Just to add in a metric that I just think would be interesting, just overall, the number of illegitimate requests or something that comes in that's either spam or someone who's not who they say they are. I'd just be really curious to see why those happen and what makes them up, and because I'm sure that'll eventually, kind of flood these requests once they become way more commonplace.
Cameron, I got a great example of that because I experienced it myself. I got one request. I would call it a shadow request. It was more of a generic one. And it turned out once they came clean after a bunch of cross questions from myself, came from I'll leave them unnamed, but it was a university research group looking to track the responsiveness of random organizations within a geographical area, which, to me is kind of, ethically on the line, I would say, but it's definitely
if not fraud.
Yeah, exactly. More or less.
But
the only thing I would add, oh, sorry, Vijay. Yeah, the only thing I would add, as well as, being able to track data, I would say bi-directionally, both from your data sources and back. I think it speaks a lot to knowing from a data quality perspective that you're normalizing data out of these silos into your solution properly. It's always a good metric to track. You don't have to spend a tremendous amount of time on it, but at least that your pathways both in and out of the data sources are good.
So I would like to add a couple more comments on the metric side. Anjali talked about having visibility into the inventory and data mapping. So that's a very important thing. I think you'll be surprised how many companies don't have visibility into what data they have, where it's located, what kind of data they're holding where. So having that visibility is also part of the metrics is important. And the second thing, Anjali made a comment earlier about, especially with write to delete requests, one of the things we have seen is that, yes, you will capture the reason for denying or deleting a request, but also make sure your system that is select also has the ability to go back and revalidate the deletion. That's a very important part of the process. So unless you can confirm that it is deleted and you inform the customer or the consumer that it's deleted and the data is still sitting in your systems, there could be an exposure for you. So just be careful about that. Okay. So the next question I have for you folks is, can authentication of a requester be automated confidently and securely? Who would like to take that question? Anjali or Jim or Cameron?
It's definitely hard, and it's prone to breaches and risk, right? Because once you start pulling out the information from your data stores to send a response as part of the DSR request, you are pulling out the data from the encrypted stores and sending it. And same happens with verification, right? How do you really, first step is to identify maybe one or two different modes of identification. If it's coming from directly from the customer through your trust portal, it's less prone to breach potential or leak. It's coming from aggregators or agents, that's an additional step, right? So it's a very onerous process. A lot of factors which need to be considered. So I would say it's difficult, but can be done. If you really know your data stores, you know your, you clean up regularly, you're evoking your users, you have the need to know privileges, proper privilege management, then your system is kind of clean. And then you know that the users who are requesting do exist in your system. So verification is easy.
The next
Yeah.
question I have for, sorry, Jim.
No, I was just going to add, that's right. I mean, this is one of the biggest areas where it's very tough to affect non-repudiation type situation, because it is similar to phishing in a way, right? I mean, how do you ultimately understand, unless you use, some of the technologies that we're using in anti-phishing, like DMARC verification or something like that? There's no real way to have 100% certainty, so it is difficult.
And you might come away with more personal data than you did in the first place after verification.
Yep.
Also a problem.
Yeah. So Cameron, this a question for you. I think this probably may be very applicable to you. In addition to Virginia and Colorado, Utah just passed the Utah Consumer Privacy Act. What does this tell you about the privacy regulations, where they're headed in the US?
Yeah, I think more and more states are going to do this. And I believe that that's going to kind of set the stage for something federal to come in and help, at least hopefully. I mean, even like 4 or 5 states having a patchwork set of different and varying regulations is difficult. I think until then, sort of the approach you take with other kind of compliance aspects is you just find the most restrictive one, and you have to apply that across all categories. So, it's at least as a starting point. So yeah, I think we're headed towards something more federal eventually, but I don't know how long that's going to take. And the more and more states that sign on, I think the more momentum we get for that.
Right.
It would be great from a convenience perspective to have some kind of federal clearinghouse, but obviously there's a ton of risks inherent in that in terms of the cross data flows that would be necessary to affect something like that from state to state, considering there's no standard for, there'd be no inherent data standard for a lot of these things that are enforced on a state-by-state level. But it would be easier, obviously, because I think it's a foregone conclusion that this the trend of state-by-state regulatory efforts are going to continue on and on as these things stay in the news. So forth.
Okay. Great. Thanks, Jim, Anjali, and Cameron for your participation today. We will hand it over to Selena. I think we are coming up on time. Selena, back to you, please.
Hi, thank you so much. And thank you to all our panelists today for sharing their expertise. We also want to give a big thank you to CYTRIO for sponsoring today's program, so that is free to our audience. And lastly, I do want to encourage you to click the survey link that was just put in the chat and briefly give us your feedback on today's program. It will help us improve our web conference programming, so we certainly appreciate it. And that wraps up the program here today. Thank you all so much for joining us, and we hope to see you at Summit next week and in another IAPP web conference soon. Thank you.
Thanks for having us.
Thanks, everyone.
Thank you, everyone.
Bye-bye.
Okay. Jordan, Selena, thank you.
Yes, thank you so much. That was great.
Yep.
Have a great day.
Thank you.
Good, thanks.